I'm not trying to hide the ball here, but the only issue that we run into is that pursuant to the court's ruling, the defendant isn't entitled to these procedures, and that's basically what the defendant's asking for.
Judge, on one hand, Mr. Zellinger's saying that we have it. On the other hand, he's saying we're asking for a procedure that we're not entitled to, and I'm not sure how those two things reconcile. The bottom line is I'm not asking for a procedure. I'm asking for the product of the test specific to Mr. Cooper's computer. And I'm asking for that prior to my having to cross-examine agents who have worked with this data. For example, Judge, if every file stamp on a particular day, if every one of them shows as invalid, and that officer knows it, I should be able to go through that with them item by item and have them explain exactly why it is that that's invalid. And as of today, I don't have that from them.
Did you have something else you want to add?
You're right. I'll just say that statute that I was talking about is pursuant to 15A 908A, and that was heard on this motion to compel discovery months and months ago, and I can provide the court with the case law about that issue. It's State v. Stevens from 1978, United States v. Nobles. This information is not Brady material. The court already made a ruling on this. And we're back in the same argument that we were months and months and months ago. What I would just say is that the defendant has the report of these officers, which is that there was no tampering on this computer. They found zero evidence of tampering on the computer. That's what Agent Johnson said. That's what Agent Chappell's report says. So at this point, they don't like that answer, so they want to claim that there's a discovery violation to somehow impeach that. And the fact is, we can't change that answer. The defendant has the computer, and the defendant can cross-examine them with the results of what they found on that computer. But the fact is, there's no Brady material because there's no tampering on that computer. And just because a computer tool that the defendant used might pop up an invalid timestamp doesn't mean that it's Brady material.
It's actually a computer tool that the Federal Bureau of Investigation used that showed an invalid timestamp in addition to our expert. So it's not that we are talking about some anomalous result that is explained by our expert doing something untoward with the computer. This is their result. So this is, in fact, indicative of tampering with the computer. And even Special Agent Johnson said that one possible way that you can explain a timestamp that appears in this fashion is if somebody puts a file on a computer from a different source. And he specified from a CD or a DVD at that time. But in fact, it can be from any additional source, which is exactly what we've been claiming all along. So as to whether or not they call it exculpatory, that's not their decision. Furthermore, Judge, under 15A 908, subsection B, it's clear that the court may permit a party seeking relief under subsection A, which is protection, to submit supporting affidavits or statements to the court for in-camera inspection if thereafter the court grants an order under subsection A, the material submitted in camera must be sealed and preserved, and in the records of the court to be made available to the appellate court in the event of an appeal, which it certainly has not been. And beyond that, Judge, specifically in the motion to compel, the court's order with respect to the question of details of any opinion that was sought or received as to what entries one would expect to find if the IBM ThinkPad had been used to initiate a telephone call at either 6:05 or 6:40 on July 12th and underlying data, that was deferred while the state seeks answer. That was not subject to any national security provision, and they didn't ask for that. They said that they were going to get an answer to that question, and we never got one until Special Agent Johnson testified from that witness stand.
He said that there was no evidence.
He said that he did look and that there was no evidence, which by definition would be exculpatory information.
That exculpatory information which had already been provided to the defendant through getting the computer to them. And, Your Honor, what I would say is the court's made its ruling on both this motion to compel
Months ago.
and today. The jury's sitting back there. There are rulings that this court has made, and I don't understand what we're doing at this point besides grandstanding for the camera.
In part, Judge, this is in specific request that the court enforce, in part, the order that it had put in place on the motion to compel. That was the court's order that it was to be deferred until the state seeks an answer. The answer was not supposed to come from the witness stand. It was supposed to come in discovery.
The objections noted for the record, overruled. Your motion to strike the testimony as I previously ordered is denied.
If I could constitutionalize this, Your Honor, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 1, Sections 19 and 23 of the North Carolina State Constitution. We would also move to have a copy of the MFT provided forthwith and have an opportunity to review that copy prior to cross-examining yet another computer expert.
Do you,
Your Honor, I'm happy to provide whatever the court orders, but what I would say is that that item is already on the computer. So
can you point it out on a bait stamp page so we can put this issue to rest and bring the jury in and try this case?
point out the
MFT, the thing
No.
he's asking for.
no. As far as I understand, it's it was on the image hard drive. I don't know how to. We didn't bait stamp every byte of data on the image hard drive, so I don't know how to pull out the MFT. But I'm happy to provide that to the defendant. I just think it's already in what the defendant has. It's part of that discovery, part of that image hard drive the defendant received when Agent Johnson made it an image copy.
That's the equivalent of saying that since I've got a bloody T-shirt, that I have the DNA sequence that is part of, that makes up the blood. It requires a great deal of work and a tool to extract it, and the different tools will extract it in different fashions. The one that I extract will not be adequate to cross-examine Agent Chappell. I need to be able to actually use the version that he extracts when cross-examining him about it.
Is that version protected under the prior order?
I believe so, Your Honor. I believe that that entails the procedures and policies, and pursuant to 15A908, the court ruled that that is not to be discoverable.
Judge, it's not a policy or a procedure. It is the copy of files on the computer. It has nothing to do with how they're doing anything. It is simply the byproduct of a test, and it is specific to his computer. It's a list of every single file on the computer.
That you can get through your expert.
In a very different fashion, Judge. Different tools are going to render it in different ways. I can't cross-examine an agent over something that he's not familiar with. His tool may render something invalid if it shows a time or a date as of being created in 2300. Ours may simply give you the date 2300. There are different values associated with different fields depending on how it's extracted. And the tools, if this is some sort of national security issue, the question would simply be what tool they are using, and if they're using a readily available tool, which thus far all we've heard of is Forensic Toolkit and Net Analysis, which anybody can buy on the internet freely, unless they are using some super secret special FBI tool to extract an MFT, there's no national security issue here.
Your Honor, the defendant just said he wants the data from the computer. The data from the computer the defendant has. He has an image copy of everything we have. He has the bloody T-shirt, for instance. Now, what he wants is the procedure for how that bloody T-shirt essentially is examined, and the court has made a ruling on that, and the defendant is asking the court to subvert that ruling at this point. If we need to litigate that,
No, we need to try this case. They've been sitting back there for 25 minutes, and I've made my ruling. The objections are all noted for the record. It's all constitutionalized, and we need to proceed. If you'll bring in the jury, Mr. Ligon.